Well, Doug, I'm supposed to be brief. Would you please do us the honor and explain to us what this appeal thing is all going to be about?
Okay, all right. Well, thank you very much, Ernst. You gave me 2 pages of notes and told me to be brief too, but I never did follow orders that well. First of all, I want to say how very pleasant it is to be back to see you all again and have the opportunity to talk about the things that have happened over the last year, which I'm not going to do. One of which was the opportunity which we had for the first time to visit Germany and to see the beauty of the country that so many people were trying to have understood better in the world. And I think that was one of the most magnificent experiences I've ever had in my life, and one which would take far too long to explain, but something that deepened my understanding of why so many of you are here. I did come away from one place not far from the Hotel Turkin with a brick, but I'm sure no one else would understand that. In any event, I'm primarily interested in communicating about the appeal, and I'd like to explain that, first of all, it's a review of the evidence on the transcript. No new evidence is admissible. Everything has to be in the record of the proceedings, typed into the books that we have, and we have several things to do that have been done and several more that have yet to be done. The first thing that had to be done was the preparation of the transcript, and Ernst has obtained that with well over $13,000 in fees to the court reporter, which had to be paid and have been paid, and the court reporter has now delivered the transcript, and that was done on the 24th of December, just before Christmas. A little Christmas present for Ernst was the boxes of transcript, which you may have heard about. Then within a month, which was yesterday, Friday, we had to deliver a couple of things. We had to deliver the transcripts to the court. We had to deliver an appeal book, which included several documents, including the indictment. But we didn't do the latter thing, but we did deliver the transcript yesterday, both to the court and one copy to the prosecutor. What has to be done again by the 24th, roughly, of February, about a month from now, we'll be in the position of having to file the appeal book and also to get several things set before a court, we hope. One of them is the date and the time of the appeal, where and when it will take place. We have to get a date fixed so that we can then prepare another large book which includes all the arguments and all the legal authorities, and that's called the factum, and that comes sometime just before the hearing of the appeal by about a month. Around the 24th of February I should be back, at which time we'll file our appeal book. Then we have to go before the judge and, as I say, get the date fixed. At the same time we'll be fixing the details of precisely what will be in the factum. We may have 30 pages or more of argument, which we'll have to delineate in the factum. Much of the work that's being done now in reading either the transcripts or looking at the charge to the jury is finding the specific reference over 5,000 pages of where a judge or a person says a specific thing. So that's being done by anyone who wants to help. And Ernst and I have been discussing all day long how we would coordinate that together with Eric and Jürgen. And we're working to help coordinate our efforts so that we don't have to repeat everything from here to Victoria. At our end, Kelty's been working very hard in going over the transcript, finding authorities that are legal cases that support our arguments on the appeal. Much of that work will be done there, while the work in terms of looking at specific parts of the transcript, finding things in the transcript, will largely be done here. Then on the 24th we'll put those two series of probably 30 files together and begin to prepare the factum, which will be our argument of the facts from the transcript and the law that we have found to support it. So we may be hearing an appeal, or may be presenting the appeal in June. We may have to go over to September, but at the moment we don't yet know. So basically that explains, I think, a few things about the time. There's the stages of the appeal. We've described, we've filed the transcript. We now have to file the appeal books, which will be ready by the 24th of February. At that time we'll get a date for the appeal, and from there we work on the factum, which is a book about the arguments, and when that is done, then when the appeal date arrives, we argue. We're going to ask for 10 days for the time in which we would present our arguments. As I say, no new evidence is generally admissible. and none will be probably presented. And then the last question, what I was told I should speak about, was what happens if we lose. Well, I think the first thing that happens if we lose is that we appeal again to the Supreme Court of Canada for leave to appeal, and I think we'll carry on this fight till the very end, no matter what. But the obvious thing that would happen if we lose is the widespread realization that you can't even publish differences of opinion in this country, and it is dangerous and difficult for anyone to be having a different point of view. At the same time as this appeal is going on, many of you could be, and some of you are, writing letters to make this publicly known, to make more people realize what's really at stake here is far more than the opinions of Ernst Zundel or Doug Christie or anyone in this room. It involves the right to hold a similar opinion or any opinion in pursuit of the truth, and this surely is exemplified by the attitude of the 4 Toronto University professors who tried to stop an ambassador of another country from being able to express even a justification for his country's views. It's a far wider fight. In fact, we could take this fight far wider now in trying to make people aware of what is really at stake. And it isn't just the opinions of Ernst Zundel. It isn't just the right to publish what is obviously researched and supported by a great deal of information. It's the right to think, in fact, in what was once a free country. If there's any value in freedom, it must be to be able to search for the truth, and this is what is at stake here. And the terror that is being disseminated in both this case and in Jim Keekstra's case, and now in Gary Botting's case, who had the nerve to come forward and speak that this article was useful in understanding a different point of view, he, being a professor of English at the University of Red Deer, is now himself in jeopardy of losing his job. This kind of intellectual terror must be stopped, and we are the only people who are fighting to stop it. I might say that we're going to have to fight some big and powerful people, but I had the pleasure of being in a battle with someone of considerable prestige in the country myself recently. The president of the Canadian Bar Association wrote a letter in the newspaper called the Canadian Lawyer Magazine, in which he said I was an embarrassment to the profession. He said that my motives were not the defense of the accused, but the promotion of myself in terms of publicity. He had done what I thought was improper in speaking on behalf of the whole profession to condemn someone whose views he didn't particularly like, and he misquoted and misstated a number of things, so I complained to the Law Society of British Columbia. And I waited a long, long, long time until Wednesday of last week, when I received the outcome of the inquiry of the committee set up to investigate my complaint, and they gave to the president of the Canadian Bar Association a reprimand for his letter, in which they pointed out in the last paragraph a quote from a case in which the statement was made, "Even the greatest of our profession must at no time arrogate to himself the right to demean the motives of even the least of our profession." So there was no doubt who was the greatest. Nonetheless, it does show that none of us should be on the defensive at any time. We have no reason to be on the defensive, and when we take the stand of what is right and true and make very clear our position that we will fight for that, the enemy disappears or the enemy will be vanquished. It only takes the courage to fight. And I've always found that among each and every one of you who I'm well aware have shared with us in this fight, a realization of that fact and an encouragement in that realization, because you have demonstrated through your commitment to helping Ernst that none of us will stand alone, that each of us will support each other in every and all struggles, and that we are united by the efforts of those who try to destroy us, and will never be destroyed in that.
One thing you forgot.
I did?
How does it look inside the appeal court?
Oh, sorry.
The mechanics.
Right. Yeah. Okay, that's simple enough. There's 3 judges up on the bench, and they look down on 2 counsel and a whole pile of books on one side and a whole pile of books on the other side, and in front of every judge there'll probably be another pile of books. And what basically happens is that the appellant presents their argument, supported from the factum and revealed in the transcripts, references made to them. Then a whole bunch of legal authorities and books and copies of transcripts of, not transcripts of trials, but reports of other cases are filed with the judges, and arguments are made from them. And then, of course, the other side gets a chance to reply, and then we have a right to rebuttal to what they have said. And that's basically how it goes. It's an argument between two lawyers that goes on for probably 10 days.
Public allowed in?
Yes, the public are allowed in, and it's open to the press.
Will it be in Toronto? Yes, we'll be here in Toronto.
It'll be in Toronto, and as a matter of fact, Mr. Griffith will no longer be representing the Crown. Nobody knows. I don't, anyway. He's the representative of the Crown is now someone called Douglas H. Hunt, QC. He is the Deputy Director of Criminal something or other for the provincial government of the Attorney General's Department. His initials are DCH and mine are DHC. Should be an interesting battle, but I'm not a QC, and I gather not long from now he won't be either.
That's right.